Welcome back to the Deep Dive. Today, we're tackling something that sounds administrative, but it's actually pretty high stakes in the world of international patent filing.
Definitely. It might seem like just paperwork, but get it wrong, and the consequences can be severe.
We are continuing our spoken overview series on the Manual of Patent Examining Procedure, the MPEP, and today we're zeroing in on a really key section in Chapter 200.
That's Chapter 200, Types and Status of Application, Benefit and Priority Claims.
Exactly. And the specific bit we're diving into is MPEP Section 215. It's all about the certified copy of foreign application. This isn't just, bureaucratic box ticking. This section is basically the gatekeeper for locking in your original foreign filing date.
That's absolutely right. For you, the listener, especially if you're involved in filings across borders, this is critical. It governs how you legally secure the benefit of that earlier foreign filing date.
And why does that date matter so much?
Well, it's all about prior art. Without locking in that earlier priority date, you become vulnerable.
Vulnerable how?
Okay, let's paint a quick picture. Say your U.S. application gets filed on July 1st, 2024, but you're claiming priority back to a foreign application filed January 1st, 2024. You need to properly secure that January date.
Right.
If you mess up the requirements in Section 215, maybe you don't file the right document, or you file it later, you could lose that January 1st date.
And if that happens?
Then anything that happened between January 1st and July 1st, maybe a competitor published something, or even your own product went on sale, that becomes what we call intervening prior art.
And that could be used against your U.S. application.
It absolutely could. It could potentially kill your patent before it even gets off the ground. So nailing the MPEP 2 and 15 requirements, it's pure risk management for your business.
Okay, so given those potentially catastrophic stakes, let's start with the basics. What exactly is a certified copy in the eyes of the USPTO? Why are they so strict about it? Why not just a regular photocopy?
Good question. It comes down to proof. Verifiable proof. The whole point of claiming priority is linking your U.S. application back to that specific document filed in another country on that specific earlier date.
So they need certainty.
Exactly. Certainty that the document is authentic and unchanged from the original filing. A simple photocopy doesn't provide that legal assurance.
So what makes it certified?
It needs to be two things. First, it has to be a copy of the original foreign application as it was filed. Second, and this is crucial, it must come with an official certification from the Foreign Patent Office where it was first filed.
That certification is the key piece then.
It's the absolute key. It's the official stamp saying, yes, this copy matches what was originally submitted on that date.
Now, I think one potential pitfall, maybe you can clarify this, is thinking that any official-looking document from the Foreign Office will do. Like, what about a printed copy of the foreign patent once it's granted?
Right, and that's a common mistake. Practitioners sometimes get tripped up here. You cannot just submit a nice, clean copy of the issued foreign patent document itself.
Why not? It came from the Patent Office.
Because the application might have changed during prosecution in that foreign country. There could have been amendments, maybe translation tweaks, other alterations. The certification needs to explicitly tie the copy back to the application as filed.
Ah, the snapshot in time.
Precisely. That moment you secured the priority date. The certification guarantees you're looking at the original, immutable content for priority purposes. It distinguishes it legally from a later, possibly modified, published patent.
Okay, that makes sense, but it also sounds like it could be a real administrative headache, especially if you're filing in many countries. Are there ways to streamline this?
Thankfully, yes. The USPTO recognized this burden. The main efficiency tool here is the Priority Document Exchange Program, often called PDX.
PDX, how does that work?
Well, if the Foreign Patent Office where you first filed is part of the PDX program, the USPTO can often retrieve that certified copy electronically, directly from the other office.
So the applicant doesn't have to physically get it and send it in?
In many cases, no. It's a huge time and cost saver. It shifts the burden, though, the applicant still needs to make the proper request and ensure the authorization is in place for the exchange, but it avoids a lot of manual handling.
So the main ways are direct submission by the applicant or this electronic PDX route.
Correct. Those are the primary pathways.
Let's talk timing. You mentioned the danger of intervening prior art if you lose the date. So what are the deadlines? How long do applicants have to get this certified copy filed?
Timing is absolutely critical in patent law, as you know. The rules here are mainly set out in 37 CFR 1.55. Generally, you need to file the certified copy by the later of two dates,
Okay, what are they?
either 4 months from the actual filing date of your U.S. application or 16 months from the filing date of the foreign priority application, whichever gives you more time.
4 months from U.S. filing, or 16 months from the foreign filing. Got it.
Mm.
What about PCT applications entering the U.S.?
Good point. For those international applications entering the U.S. national stage, the timing follows the specific rules under the Patent Cooperation Treaty and its regulations. Slightly different framework, but the same principle applies. There are deadlines.
And what happens if you miss these deadlines? Let's say the 16 months runs out.
If you don't submit the required documents within those timeframes, the priority claim is considered legally waived. Gone.
Just like that, waived. That sounds pretty final. Is there any way back if it was just an oversight, an honest mistake?
Well, waived is the default legal status, but patent law often provides a safety net, albeit a complicated one. You can potentially recover those rights.
How?
Through a petition. Specifically, a petition to accept an unintentionally delayed claim for priority. This is covered under 37 CFR 1.55e.
Okay, a petition. Is that straightforward?
Not at all. It's described as a high-friction process. It's not automatic. You're essentially admitting an error and asking the USPTO for legal forgiveness, and you have to meet some strict requirements.
What are those requirements?
There are 4 mandatory things you have to submit for the petition to even be considered, let alone granted.
Okay, number 1.
First, the priority claim itself. If you hadn't submitted it properly before, you need to actually make the claim.
Makes sense. Second.
Second, the certified copy of the foreign application unless one of the specific exceptions applies, which we can talk about later.
Right, the core document.
Third, the petition fee. And it's not trivial. It's the fee set out in 37 CFR 1.77 meters, which can be quite substantial.
Okay, claim, copy, cash. What's the fourth? It sounds like the tricky one.
It is. The fourth requirement is a statement. You have to provide a statement declaring that the entire delay from the date the claim was originally due right up until the date you finally filed, the claim was unintentional.
The entire delay. That sounds like a high bar. How hard is it to prove that, especially if the delay was, say, over a year?
Extremely hard. That's the crux of it. The burden of proof is completely on you, the applicant. And unintentional doesn't just mean, oops, I forgot.
What does it mean then?
It means you have to show, essentially through due diligence and investigation, that there was never a deliberate decision not to file it on time or not to correct the error sooner. You need to demonstrate a continuous lack of intent during the whole period of delay.
So you might need records, emails, procedural logs?
Potentially, yes, especially as the delay gets longer. The rules actually tighten the screws if the claim is filed more than 2 years late.
2 years. What happens then?
If you're filing that petition more than 2 years after the priority claim was originally due, the standard statement isn't enough. You have to provide additional explanation and likely supporting evidence to really establish that the entire multi-year delay was truly unintentional. There's even specific guidance on this.
Wow. So basically digging yourself out of that hole gets much deeper and more expensive the longer you wait.
Absolutely. You're looking at significant legal and administrative effort, plus that petition fee, with no guarantee of success if you can't meet the unintentional standard for the entire period.
The clear message seems to be, get it right the first time. Pay attention during that initial 4 to 16-month window.
It's infinitely cheaper and less risky than trying to fix it later with a petition. Prevention is far better than the cure here.
Okay, let's shift to some ways to make compliance easier. We talked about patent families, continuations, divisionals, reissues, where you often claim the same foreign priority. Does the USPTO really make you submit that certified copy again and again for each child application?
Thankfully, no. That would be incredibly redundant. The MPEP and the rules provide some very sensible exceptions here, mainly under 37 CFR 1.55H. This covers situations where the certified copy is already on file in a related U.S. application.
How does that work in practice?
Well, there are 2 main scenarios. The first is for reissue applications. If you're filing to reissue a patent and that original patent already contains the necessary certified copy, you're generally set. You just need to properly identify that patent in your reissue application.
So point back to the parent patent file.
Exactly. The second, and probably more common scenario, involves continuing applications. This includes continuations, divisionals, and continuations in part, or CIPs.
Right.
If you file one of these applications and it claims benefit under the usual sections like 120, 121, etc., to a prior filed U.S. non-provisional application, and that prior application already has the certified copy on file.
Then you don't need to file it again.
Correct. You just need to clearly identify that prior application number in your new application's paperwork, like the application data sheet, ADS. You're basically telling the USPTO, go look in that file, the proof is already there.
That's a huge efficiency gain. It means the USPTO verifies it once for the family, and the record carries through electronically.
Precisely. It avoids cluttering up the file records with duplicates. The system just needs that one verified anchor point for the priority claim within the family tree.
Were there any other sort of tactical tools? What if you're right up against a deadline and the certified copy just hasn't arrived from the Foreign Office yet?
Yes, there's a limited provision for that too. The rules allow for the use of what are called interim copies of the foreign application.
Interim copies, like just a regular copy.
Sort of. It's basically a placeholder. You can submit a non-certified copy, but it must be properly labeled as an interim copy and submitted with a specific cover sheet.
Does that satisfy the requirement then?
Only temporarily. It buys you time, maybe gets you past an immediate deadline, but it doesn't fulfill the ultimate requirement. You are still obligated to provide the actual officially certified copy later on during the prosecution of the U.S. application.
So it's a tactical delay, not a solution.
Exactly. A temporary measure for when you're in a bind, but the full certified copy still needs to follow.
And what about the examiner's role in all this? Once these documents are filed, either the certified copy or reference to a parent file, what does the examiner do? Just check a box?
They do more than just check a box. Examiners are specifically instructed to review for compliance and, importantly, for consistency.
Consistency with what?
They check that the details on the certified copy itself, things like the application number, the country, the filing date, actually match what you've claimed in your application data sheet, the ADS.
Ah, so the documents need to line up with the data submitted.
Precisely. If there's a mismatch, say, the certified copy has a slightly different application number or lists the wrong country, or if the copy seems incomplete, the examiner will flag it.
And then what happens?
They'll issue a notice, usually a requirement for information or a notification, telling the applicant they need to correct the error. This often involves filing a corrected ADS or maybe even a supplemental declaration to make sure the official record accurately reflects the foreign filing details proven by the certified copy.
So it really emphasizes that administrative alignment. Everything needs to match up perfectly.
It does. The whole process described in MPEP Section 215 really drives home that securing international priority rights isn't just about having filed first somewhere else. It's about rigorous, detailed, and timely administrative execution here in the U.S.
It's less about your intent to claim priority and more about following the procedural steps to the letter.
Exactly. Because if you fail, you risk that potentially fatal blow of intervening prior art coming into play against your invention. That can completely undermine patentability.
A sobering thought. It really puts the onus on meticulous record keeping and deadline management.
Indeed. And that brings us to maybe a final thought for you, the listener, to ponder. Consider the hassle we just discussed, the petition process, for unintentional delay. It involves complexity, substantial fee, intense scrutiny, especially after 2 years.
Right.
So the question is, how does your organization value that upfront, meticulous administrative effort? When you weigh the cost and resources needed to get it right initially within that first 4 to 16 months against the potential cost, risk, and legal fees of trying to fix a mistake years later, which path holds more value?
It certainly seems like flawless execution early on is the cheapest insurance policy you can buy in this context.
It often is. It's a strategic calculation every applicant or their firm needs to make.
Well, that's a fantastic place to wrap up our deep dive into the surprisingly high-stakes world of MPEP Chapter 200, Section 215. Thank you for walking us through that.
My pleasure. It's detailed but crucial stuff.
And we also like to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series. Just a reminder, this summary of the MPEP was generated using AI tools, including ChatGPT and NotebookLM. It's intended for general educational and informational purposes only. It may contain errors or omissions, and it is absolutely not legal advice or a substitute for formal instruction. For any authoritative guidance, please consult the official MPEP itself or a registered patent practitioner. We'll catch you next time for another deep dive.